is now convened in criminal number 12716, caption the State of Iowa versus Trevor Feauto. Photos in the courtroom seated next to his lawyer, David Richter. Ben Smith is here representing Sac County and the State of Iowa. This matter has a circuitous route to get here today. There have been some things that have troubled the court, and was uncertain as to how it was going to resolve itself. It's my belief that we have reached that point, and I'm prepared to proceed. But I have questions that I may want to ask of the lawyers and Mr. Feauto. I would point out that I've received a substantial amount of affidavits, interest. It would appear clear to me that if this matter goes to trial, it could not be tried in this county, but it would have to be tried in another county, and that's still an option, folks. Having said that, Mr. Smith, are you ready to go?
Yes, Your Honor.
Mr. Richter?
Yes, we are, Your Honor.
Mr. Feauto, have you had a chance to visit with your lawyer today before you came in here?
Yes, Your Honor.
And you know what is likely, or you know why you're here today?
Yes, Your Honor.
And are you satisfied with the legal advice that your lawyer has given you?
Yes, Your Honor.
During the course of the next minutes, if you have questions, raise your hand. I'll stop, and I'll let you visit with your lawyer. Do you agree to do that?
Yes, Your Honor.
Mr. Smith, why don't you address the court and kind of set the table, so to speak. Tell me what your expectations are, what amendments, if any, are being made, and what plea offers have been made. And then I'll let Mr. Richter speak on behalf of his client, and then I'll have to talk with Mr. Feauto.
Thank you, Your Honor. It's the state's understanding, Judge, that today the defendant, Mr. Feauto, will be pleading guilty to counts 3 and 4, both homicide by vehicle caused by recklessness, both C felonies, for one each for the death of Lindsay Quirk and Haley Jacobson. It's also the state's understanding that following the entry of defendant's guilty plea, that will proceed immediately to sentencing, and at which point in time the state will be making its recommendation and defendant the same. The state is anticipating that, pursuant to discussions back in chambers and discussions had throughout the last year or so, that the court, upon certain satisfactions, will enter an order consistent with the plea agreement of the parties. That's the state's understanding, Your Honor, of what's going to happen today. If there's anything that the court would want to know, I'm sure I can fill you in as best that time.
Mr. Richter, is that an accurate statement of what discussions you've had with the state and in turn passed on to your client?
It is, Your Honor.
Mr. Feauto, did you understand what he said?
Yes, Your Honor.
And you're proceeding today based upon those discussions?
Yes, Your Honor.
I'm not bound by anything right now, you know that.
Yes, Your Honor.
Well, I've got to ask you some questions. They relate to the accounts 3 and 4, both of which are Class C felonies, both defined as homicide by vehicle, the result of recklessness. Carries with it the potential of a 10-year jail sentence, minimum fine of $1,000, a maximum fine of $10,000. Keep in mind there are 2 counts here, so all of these things would be doubled. The driver's license would be suspended for 180 days. Is that not correct, Mr.
I couldn't find that.
Well, that would be pursuant to the OWI.
Yes, Judge.
All right. The dare charge of $10 will be imposed. Mr. Smith, in your sentencing order, which you gave me for review, you spoke to the mandatory minimum sentence, but you had it highlighted in yellow. What's your belief on that?
My belief, Your Honor, is that there is no mandatory minimum for the Class C.
That's right.
Okay.
That's right. Do you agree with that, Mr. Richter?
I do, Your Honor, and I already marked it.
Okay. Mr. Smith, direct my attention to that paragraph which relates to the civil penalty units. I know we spoke of it.
It should be in paragraph 11, and it should be subparagraph C, which didn't make it in here for whatever reason.
Well, that amounts to $150,000, I believe. Is that not correct?
That's correct, Your Honor, and that would be for each case.
And that's for each case.
Yep.
Court cost restitution for attorneys privately employed. There'd be a 35% surcharge on any fine that would be given. And since there are 2 counts and actually 3 counts if you include the misdemeanor OWI, you could be sentenced consecutively or concurrently. Mr. Feauto, do you know the difference?
Yes, Your Honor.
Mr. Smith, there are other housekeeping matters included in any order, but do you know of any of the essentials that I've left out of this?
No, Your Honor.
Mr. Richter, do you?
I do not.
All right. Mr. Feauto, you have a right to a jury trial. You have a right to an attorney even if you can't afford one. If you plead guilty to these counts, you're going to waive this right. Do you understand this?
Yes, Your Honor.
The state must provide evidence to prove beyond a reasonable doubt that you're guilty. They got to do so by proving beyond a reasonable doubt that you're guilty, and if they don't, and you plead guilty, you'll provide the evidence and waive this right. Do you understand this?
Yes, Your Honor.
You can subpoena witnesses to support your case. The state has to tell you who their witnesses are in advance. If you plead guilty, you'll waive all or a portion of these rights. Do you understand this?
Yes, Your Honor.
If this matter went to trial, a jury would have to find you unanimously guilty of these charges before the court could enter judgment. If you plead guilty, you'll waive this right. Do you understand this?
Yes, Your Honor.
You believe you understand the possible penalties and the rights you're given up?
Yes, Your Honor.
Have these things been explained to you by your lawyer?
Yes, Your Honor.
Count 3, homicide by vehicle in a reckless manner. Class C felony, how do you plead guilty or not guilty?
Guilty, Your Honor.
Homicide by vehicle, a Class C felony. In count 3, how do you plead guilty or not guilty?
Guilty, Your Honor.
I believe, Your Honor, you said count 3 twice. That could be.
I'm sorry. I was reading off of your the sentencing order. The first one is count 4 and count 3. There's count 3 and count 4, both of which are homicide by vehicle in a reckless manner. You plead guilty to both. True?
Yes, Your Honor.
Is this a voluntary decision on your part?
Yes, Your
Are
Honor.
you thinking clearly today?
Yes, Your Honor.
Any threats or promises made to you to cause you to plead guilty today?
No, Your Honor.
I know that you expect to go ahead and be sentenced today, but until such time as I enter judgment, I'm not agreeing to anything. Do you understand that?
Yes, Your Honor.
Mr. Richter, you may want to help your client through this, but you need to address counts 3 and 4 and make a verbal record as to what your client did, or he must make that record that constitutes a violation of this law.
He has been advised by me, Your Honor, that this requires recklessness. I explained in some significant detail to him that if the blood test gets in, that OWI, the test he had, would be per se negligence. That is basically why we're here today, and that's the large weighing item that has me advising him that this is the right thing for him to do. In other words, there is a challenge to that blood test, and a significant challenge. But the danger to us, if we are wrong, is severe. And he understands the risk involved both ways, and he has decided to take the method we're going today, Your Honor.
Well, I may have further questions
Well, that's
about that
fine.
when we get into the sentencing portion of it, but I don't think that if you can be too careful at this point as to identifying the lengths that you went with your client so that this is his decision and not yours. Understand?
Sure.
Now I need to have you tell me what you did. How about, Mr. Richter, you need to help him identify each of the counts so he can see what we're talking about.
It requires recklessness by you, Trevor. You are pleading guilty to 2 counts, and each of those require recklessness. And you and I talked at length of that. Driving under the influence of alcohol is per se reckless in Iowa.
Mr. Richter, let's back up a minute. Let's go to the trial information, and let's use that as the foundation for which Mr. Feauto.
Okay.
I'm not gonna ask him questions myself. That's not my job. But he needs to identify those counts and provide verbal confirmation that he did those things.
Count 3 and count 4, Trevor, is what the judge is addressing now. And it alleges that you drove a motor vehicle in a reckless manner, and the recklessness unintentionally caused the death of Bailey Marie Jacobson. That's count 3. Do you agree that it is reckless to drive, testing what you did for alcohol?
Yes, Your Honor.
And the same question with regarding count 4, Lindsay Lou Quirk. Do you agree that it is reckless to drive and have in your system while you're driving .137 in alcohol?
Yes, Your Honor.
I don't want to take this too far, but I need to establish, where did this take place? In Sac County?
Yes, Your Honor.
It says on the trial information approximately August 23rd, 2014. Is that true?
Yes, Your Honor.
You've identified your belief that you were reckless in the manner in which you drove your vehicle, right?
Yes, Your Honor.
And it unintentionally caused the death of Bailey Marie Jacobson.
Yes, Your Honor.
The same set of facts would apply to the unintended death of Lindsay Lou Quirk. Is that true?
Yes, Your Honor.
Mr. Smith, are you satisfied with this recitation?
Yes, Your Honor.
Mr. Feauto, Mr. Richter, do you know anything that I should add to this to get this record completely right?
No, Your Honor.
Mr. Feauto, this is a significant matter talked about the possible penalties which could be imposed upon you. They are significant. And the rights you've given up, your right to a trial by a jury, one that could vindicate you of all charges. I want you to think about that for a minute, okay? Is it still your desire to plead guilty to counts 3 and 4?
Yes, Your Honor.
Should I accept your client's pleas, Mr. Richter?
I would say yes.
Okay. Mr. Smith, do you believe I should accept his pleas?
I see no reason why the court should not accept the defendant's pleas.
Was there any exculpatory evidence that you didn't share with Mr. Richter?
I turned over everything the state had to Mr. Richter, Your Honor.
The court finds that the defendant understands the nature of the charges, the possible consequences, the rights that he's given up, and has recited an adequate factual basis for receiving your 2 guilty pleas. And I do. We've already received a pre-sentence investigation. I reviewed that again today. It's made a part of the record. And it's my belief that at this point you want to go ahead with sentencing. Is that true, Mr. Feauto?
Yes, Your Honor.
Stay agreeable to that?
Yes, Your Honor.
Mr. Richter, are you okay?
Yes, Your Honor.
Now, I'm sure you discussed this, but I have to talk about it too. You can challenge the plea that you just entered, the pleas that you just entered, by filing what's known as a motion and arrest of judgment, contending that I left something out and misled you, that would otherwise change your mind about pleading. But to do so, you have to file it in a timely fashion, no later than 45 days from the entry of the plea, but at least 5 days prior to the date of sentencing. Well, if we go ahead with that today, we're going to go right by that right. Has that been explained to you?
Yes, Your Honor.
And do you want to still go ahead and go to sentencing today?
Yes, Your Honor.
You won't be able to attack the plea in any sort of an appeal on a later date. Do you understand this?
Yes, Your Honor.
Mr. Richter, you've received a copy of this pre-sentence investigation, have you not?
Yes, I have.
And you've gone through it with your client.
Yes, I
Are
have.
there any corrections or additions that need to be made to this report?
No, Your Honor.
Mr. Smith, same questions. You've received a copy. Are there any corrections or additions?
Received a copy, no additions or corrections.
Do you object to me using this report in consideration, Mr. Richter?
I do not.
Mr. Smith?
No, Your Honor.
Does the state wish to present any evidence?
No, Your Honor.
Does the defendant?
No, Your Honor.
I may have some questions here
Sure.
shortly. I have received numerous affidavits, statements from people that care, and I've read all of them. It's been over the course of a few months, but each day it's reminded me to think about this. And, I think at this point I'm going to ask for the state's sentencing recommendation. And Mr. Smith, I may have questions for you.
Sure, Your Honor. I'll just go ahead and sit.
And why don't you slant your responses to me based upon this premise? Can't be any more serious of consequences. It's unusual that the state, and having been around you, it's unusual for this sort of a recommendation. And your thought process that led you to that recommendation and here today.
Thank you, Your Honor. The state's recommendation is that the defendant, as it relates to his convictions for the C felonies, that defendant be sentenced to an indeterminate term of incarceration for 10 years on each to run consecutive, but that they be suspended and the defendant be placed on probation for a period of 5 years. The defendant be ordered to pay the minimum fine, although the state had agreed previously that it would not object to defendant arguing for a suspended fine. that defendant pay all costs, fees, surcharges associated with these convictions. And I guess to address the second part of your bifurcated question is why. As the court knows, well, let me say it this way. Of all the cases that I've had in Sac County in the 6 years that I've been here, and the court knows that I've had some doozies, this one, above all others, has weighed more heavily on my mind. It's not about me, though. And what I do, and the reason why I do this, is for the families and for the victims. And there are times that I have to make decisions that aren't necessarily popular or understood. But at every turn, after every glance of the papers in this file, I saw two things, two outcomes. Either the defendant left here in handcuffs and was sentenced to a minimum 17 years, mandatory minimum 17 if they ran consecutive, 35. Or defendant walked away free. The facts of the case on their face, a horrific two-car crash, an intoxicated driver, and two deceased high school girls. Those are the facts on their face. As the state, as everybody knows, the state has the burden to prove defendant's guilt beyond a reasonable doubt. And the law requires in this case that the state prove beyond a reasonable doubt that it was defendant's intoxication that caused the deaths, as it relates, I guess, to the Class B felonies, or the defendant's recklessness that caused the deaths. Put another way, but for defendant's intoxication, Lindsay and Bailey would still be here. Considering the facts of the case, that the intersection was uncontrolled, that arguably and likely defendant had the right-of-way, and the evidence showed, I guess, demonstrated at least to my satisfaction, or dismay, however you want to look at it, that the nature of the intersection of itself posed some difficulties as far as visibility. So, in reviewing the case file, in talking to the parents, and trying to figure out what is justice in this case, I know justice in this case is not a not guilty. That's, to me, would be an aberration of justice if the defendant were to walk out of here. But on the other end, knowing that I would present this case to the jury and I'd have to convince 12 people, probably not from Sac County, I would have to get 12 people to agree beyond a reasonable doubt that given all those facts, the nature of the intersection, that it was defendant's intoxication that caused the deaths. That had defendant been sober or not drinking, that the girls would be alive. That's a very, very difficult place to get to, in my mind, considering everything. With that, I thought, what can I do? What should be done? What is justice? I reached out to the defendant and came to an accord, and where defendant, as you just took his guilty plea, admitted to being criminally responsible for the deaths of Lindsay and Bailey. The same as if a jury convicted him, no different. He admitted criminal responsibility. And, Your Honor, that term's an accident into a crime. That's my thought process in this. I couldn't, as a state, and this is not about me, I could not allow for there to be a not guilty or nothing of criminal consequence to flow from this. We make deals all the time based on that, but, I mean, the victims and their families, their friends, we live in the same town. I mean, this is something that is affected them way more than it's ever affected myself, and it will continue from here forward. And I know that, and in knowing that, what's best, I believe what's best, not just for the state and not just in the interest of justice, but the families. Having him admit to being criminally responsible for their deaths is 100% the basis for this agreement. So I hope I've answered the court's question and maybe gotten into more detail than I should have, but that is the reason why such egregious facts, at least on their face, have resulted in the agreement that we have. Thanks.
Mr. Smith, these sort of statements always send chills up my spine, but I know that you've given me original signed statements and memorandums of record, and if these would be the victim impact statements or in the place thereof, but I have a signed statement from an Ann Jacobson, mom of Bailey, and I have signed by Brian and Lisa Quirk, parents of Lindsay, and it says that said plea offer was made following the aforesaid discussions with them, and that they respectfully request the court sentence defendant according to the terms set forth in the attached plea offer. Is that a recent signature?
That, Your Honor, is a signature that was obtained today. If I forgot, this is the families that get it. Okay, they understand. They're not happy,
Yeah.
and there's nothing that's going to make them happy, and I get that too. I'm not. Those statements aren't an admission that they're okay with this, because they're not. I'm not. But that's the realities. They were able to look past those egregious facts on their case, and at least look at it from the state's perspective, the convincing the 12 people beyond a reasonable doubt.
Right. Others, does this constitute the evidence that you want me to hear, along with the victim impact statements that I've received regarding my sentence?
You have everything, Your Honor, that the state intended to present.
Are Brian and Lisa Quirk, are you here? And you signed these documents?
Yes.
Well, I'm going to talk to you in a few minutes about the sorrow that I have on days like today. But this was a voluntary signature on your part. And Ann Jacobson, are you here? Same question to you. This was a voluntary signature on your part? Yes. Mr. Richter, Mr. Smith's statements have caused more questions for me now. Namely being, he's expressed some concern as to the likelihood of a trial victory. And that's what has brought him to this offer today. He stated that he wants an admission, a conviction, as opposed to a possible acquittal altogether. Now, having said that, have you explained, do you believe that to be true?
Absolutely, Your Honor, I believe that to be true.
Okay. You believe that you would have some likelihood of success?
I would say not some likelihood, Your Honor. I would say with the issues identified in this case, and I've gone over it with Trevor in detail, that, listen, I'm advising you buy the risk here, and I explained in detail the way the blood test went down, and that's after we got into the case. Just rough facts here, Your Honor. You've got alcohol involved with everybody involved in this accident, except maybe some passengers in my client's car. Okay, with that in mind, I had to evaluate just the raw accident scene, who was at fault. Very difficult to do. You've got who's got the right of way, did the drinking have an impact on them, how much was the driver drinking, where had they been drinking, how much was the passenger drinking. So I had to evaluate all that to give him advice. In addition to that, the blood test in this case was taken before. In other words, there was blood there, an officer comes and says, I need blood. The lady says, I've already drawn it, where's your form, I'll fill it out now. This is not a medical doctor saying that he was unable. This is a nurse, an RN, saying he was unable to give consent. That's not the issue. He doesn't even remember it, so I would agree he probably was. But the fact that it was done in the wrong order would knock out the blood test altogether. And that's where he and I spent multiple hours, and I spent many more researching. What did I think you would do faced with this set of facts? I combined the risk of that and the risk of the actual scene of the accident and said, what do I think would happen? There's a good chance that we would walk out of here with nothing. I frankly agree with Mr. Smith. I don't think that'd be right. I really don't. But there's also a chance that we would have gotten the bad one and we'd be going away to prison for many, many years to the point where it would destroy Trevor. So I believe this is a good decision by Mr. Smith, and I think it's the right thing for my client to do.
Mr. Feauto, you heard the two lawyers speak. Did your lawyer talk to you about the possibility of winning this case?
Yes, Your Honor.
And ultimately, it came down to a decision that you didn't want to take the chance.
Yes, Your Honor.
Now, you may think this is a good deal today, but a year from now, are you going to look back at Mr. Richter and say, why did you try this case?
No, Your Honor.
All right. Are you doing the right thing today?
Yes, Your Honor.
Is there anything else that you want me to hear, Mr. Smith, in the form of evidence, statements of any kind?
No, I think I would be remiss if I didn't raise, because I think I did not discuss this earlier, but, you know, the plea offer, the plea agreement would have defendant on two consecutive Class C felonies, which isn't a joke, and a probationary regiment that is not a joke, and 90 days in jail, which is 90 days in jail. So that's that the court, you know, also, I guess, considered that, which I know it has.
Mr. Richter, is there anything you want to say in any additional argument other than this that's been said?
No.
Mr. Feauto, there's a term, it's called allocution of sentence. Is there anything you want to say to me or anybody at this time before I pronounce sentence?
No, Your Honor.
I've gone through the possible parameters of sentencing a while ago. And Mr. Smith, do I need to repeat them?
Not for the state's benefit, Your Honor.
Richter, do you care to do? I need to repeat them for your benefit. Keep in mind, Mr. Feauto, that if you're sent to prison, that could be affected by your good conduct and work credits by as much as 1/2. And you the expiration of your full term. So, I've said this so many times that I've forgotten how many times, but the process by which we sentence gives evidence, and then we repeat the penalties, and then we tell the defendant that they could be affected by your good conduct. And the really only purpose of that is to suggest to you that from this moment, this very moment, what happens to you depends on you. The purpose of a proper sentence is to protect, provide the best opportunity for your rehabilitation, give you the help that makes certain that this never happens again, and protect the public from further misdeeds. And this is the type of crime, this is the crime that most defines that need. We can't ever let this happen again. And the reason we've been back here a number of times has been my reluctance to let go of the memories of Lindsay and Bailey in this fashion. But it happens. And I understand, and I know Mr. Smith, I've been with him a while now, and he does not let go of a case he knows he can win. And I presume that his analysis on this has led, not I presume, he stated that his analysis of this led into this conclusion. I don't think you need to go any further in terms of the impact of this on people than your own lawyer's emotions that were displayed moments ago. You know, I'm going to guess it's the result of his hope that you can make up for this somehow, and his feelings of despair for these two girls' families. The worst thing that can happen has happened, and I can't change that. And if you are the type of person that many people believe that you are, you're going to punish yourself a little bit every day the rest of your life. And the only option that you can to make that better is to try and do something that proves that the sentence and the recommendations and the faith that certain people have placed in you was justified. I said this before, I can't imagine, I've heard people, I've had friends that have lost children and have lost people that they care about, and they say things like, I know how you must feel. That's ridiculous. And I'm offended by people that say it. I don't know and I don't want to know. But it doesn't mean that I don't care and I don't think about it. I had a similar sentence in Boone County where a young man was involved in an accident. There were 3 of his best friends in the same car and they all were killed. And a similar type sentence occurred a little bit differently, but still, the worst had happened. I do understand the thought process, Mr. Richter, that you went through to get to this. You know, you've not let your own ego get in the way of something that was in the best interest of your client. Yes. Go ahead.
I would just like to say to the parents of the deceased kid,
Yeah.
I lost a child this way too, and it's not fun. I do know what they're going through.
You've never mentioned that to me.
It won't get better in a day or two.
And I often
It
tell my
won't
nephew,
get better in a year or two. It takes a long time.
And it doesn't
does get better after 22 years, Your Honor, I can tell you that.
Well, Mr. Feauto, you can feel the emotions in this room. And I'm not sure that these parents will forgive you. Your good life from now on will make a difference to some, and it certainly should make a difference to the people who care about you. After a great deal of thought, and reservations, reversals of my own decisions, I've reached the conclusion that this is the proper sentence, and it will be the order of the court that you will be sentenced as follows. You are sentenced to an indeterminate term of incarceration not to exceed 10 years on count 3, $1,000 fine plus a 35% surcharge, and the same sentence in terms of time frames will be imposed as relates to count. That was 3. This would be 4 as well. Will be committed to the Department of Correctional Services. The Oakdale facility will be the designated reception center. These sentences shall be suspended. You'll be placed on probation to the 2nd Judicial District for a period of 5 years. And these sentences shall run consecutive to each other. So this isn't over, Mr. Feauto. The responsibility for your success is going to be clearly in your own hands. You'll be subject to the terms and conditions of the 2nd Judicial Department of Correctional Services, which shall include substance abuse evaluation and any follow-up recommendations. There'll be a $10 dare surcharge, and you'll be assessed the civil penalty of $150,000 for each of the counts. The order will go into great detail as to the financial obligations, the methods of payments. Your lawyer will go through that when he has a copy of this. I'm going to require that you provide a specimen for DNA sampling, and I'm going to add something else to this, Mr. Smith, that may or may not happen, but I want at least the effort made. Mr. Feauto, have you been working recently?
Yes, Your
Where
Honor.
do you work?
Avery Renovations, Your Honor.
Okay. Where do you live? It says it here, but I want to make sure it's up to date.
I need to change that. I live in Cedar Rapids now, Your Honor.
Cedar Rapids.
Yes, Your Honor.
Well, however convenient you want to make this, you need to go to 3 high schools. Go to their counselor, their principal, whoever, and volunteer. I don't care if they don't want to use you, but you need to volunteer. Tell your story to them, to the principal, to the guidance counselor, what happened. And say that I would like to tell that to other students, just so they understand that and we would never know. We would, if you were to tell your story, and it was successful with one person, we'll never know that, and that's good. Do you understand what I'm saying?
Yes, Your Honor.
Let your attorney know who those schools are, and get a statement from them that you volunteered, that they've chosen not to accept that, and that should take place in the next year. Okay?
Yes, Your Honor.
Now, it occurred to me this morning driving up, I think today is D-Day, is it not?
Yes, it is.
June 6th. And of this generation, my father was a veteran, and I was proud of his service. But my understanding of that turmoil is shown in movies, and the one that sticks in my mind most recently is Saving Private Ryan. And at the very end of that movie, after they've saved him, there's a statement made to him that applies right now. Earn this. Do you understand?
Yes, Your Honor.
I apologize for the manner in which this has gone back and forth to the parties. I'm sorry for the loss of the children. These things are not extinguished in my mind when I leave here today. I need to explain that you have a right to appeal. You have a right to appeal what's taken place throughout these proceedings by filing a written notice of appeal with the clerk of court within 30 days. If you can't afford a lawyer, one would be provided for you. If you can't afford a transcript, one would be provided for you as well. The appeal bond is set in the amount of $25,000. Keep in mind, you don't file it within that time period, you lose your right. If you have questions about what took place here today, talk with your lawyer, okay? Mr. Smith, you know anything I need to talk about further?
No, Your Honor.
Mr. Rector, do you?
No, Your Honor.
Mr. Feauto, your obligation is to lead a good life.